case, an employee of the hospital ascertained the fact of eligibility, which indeed could not have been more obvious, and directed the defendant's mother to the department's representative. This was a proper discharge of the hospital's functions. When the hospital received the incomplete and unexecuted application forms, a clear duty devolved to ascertain what had happened. Indeed, evidence suggested that such inquiries were normal practice, but whether normal practice or not, it was the clear obligation of the hospital, and one that in this instance was not discharged. I am satisfied that if the hospital had made such inquiries, the problem, whatever it was, would have been straightened out, an appropriate application would have been executed, and the lawsuit would never have come to pass. The failure to make such inquiries or even inform the defendant or her mother promptly that an application had to be executed seems to me to require the dismissal of the action. It would completely frustrate the intended purpose of the Medicaid statute to permit a hospital to default so completely in its obligation in a way that forestalled the medical payment and thus the obligation in a way that you could sue the needy patient or family for the cost of the medical service. Although not necessary to this determination, the same result would clearly follow from the view ably expressed by Judge Davis in the Knickerbocker case, Supra, with which I am inclined to agree that the department, not the patient, is the primary obligor where obligation, in fact, was determined. In holding for the defendant here, I am not expressing a position in situations where the patient is primarily at fault through withholding or misstating the crucial acts or refusing to cooperate in the application. And is it necessary for me to consider the consequences of a failure for the department to authorize payment because of an error in evaluating the facts correctly? Whether an Article 78 proceeding by the hospital could then be the appropriate remedy or the exclusive remedy is not necessary to decide here. I should add that in the Society of New York case, Supra, I determined only that the third-party action against the defendant should not be dismissed under the circumstances presented, and that the hospital had established an action against the patient. Judgment may be entered for the defendant with costs, and the third-party action is accordingly dismissed without costs. The proceedings on motions of temporary injunctions restraining showing of allegedly obscene films and cross motions by defendants for summary judgment dismissing the complaint, the Supreme Court, New York County Special Term, Part 1, held that the statute authorizing the injunction against publication of obscene material, but which did not contain exceptions for material which then was taken as a whole, contained serious literary, artistic, political, or scientific value and was void for overbreadth, and that statute defining obscenity was overbroad. The words obscene, lewd, lascivious, filthy, indecent, or disgusting is contained in statutes relating to jurisdiction to enjoin the sale of obscene material, which would be construed as limiting the regulated material to patently offensive representations or descriptions of ultimate sexual acts, normal or perverted, actual or simulated, and patently offensive representations or descriptions of masturbation, excretory functions, and lewd exhibition of genitalia. How's it? Too tough?
Well, tough.